if you don't have a percentage,
Yes.
why would a company, for what conceivable reason would a company donate 100% of its profits? Because you have to take the extreme case.
Yes, yes.
That's why I give you a 1 rupee company passes the threshold that I'm a profit-making company.
I have two answers.
I have a 1 rupee profit, but I will donate 100 crores. Why would a company do that?
Technically, I can say, Mr. Bhushan has given this example that even ruling party can, any party, why ruling party, any party can feign ignorance. That somebody came and in my Dropbox not in the digital sense, in the ballot box, in the postal box, there was an envelope. An envelope contained 100 crores. Nobody donates like this. We give money like this only in pilgrimages. We don't, people would not donate anonymously. In Srinathji, people would donate 100 crores without any name. It would be an anonymous donation because that is, yes, Tirumala. That's what I'm saying. But that is, again, idealistic way. Practically, the part.
Even that is not idealistic because the assumption is that the Almighty knows who has put money in the hundu.
Your Lordship, I bow down. My Lord. There is no confidentiality. There is no confidentiality. My Lord, even the person also knows why he is donating. That is reflection of the fact that there is a line in Ganges for my Lord, because they know कि बहुत पाप किए धोना जाना पड़ेगा. So people also know that. But my Lord, the party who receives knows who has given. That you can never, my Lord, come out of. There cannot be any system where the donor and donee each other would not know.
But then, so Tushar Mehta, if this is so, why not make everything open?
But, my Lord, then the purpose is defeated. As I, my Lord,
as it is, everybody knows about or partly knows about it, partly they know about it. Only person who is being deprived is the voter. Your contention that the voters do not have the right to know after the number of decisions of this court is slightly difficult.
No, my Lord, voter, my Lord.
Because they would know that they should know.
Then I bow down and we go back to, my Lord, the earlier policy. No, that's the only answer.
No, it's not like that. That's why we said we are not for a moment saying that, look, there are 3 or 4 considerations which are very important. One, the need to reduce the cash element in the electoral process. Very important.
Reduced,
right? Second, the need to encourage the use of authorized banking channels for that purpose, which is the only way you can reduce the cash element. That's the second consideration. Third, there is a countervailing consideration. Third is incentivizing the use of the banking channels,
which is confidentiality according to us.
And therefore, according to incentivizing the use of the authorized banking channels should therefore result in greater confidentiality. But there is a fourth consideration, which is the need for transparency. And a fifth consideration, which is that this should not become a legitimization of kickbacks and quid pro quo between the power centers, whether in the states or in the center, and people who are really in that sense, they are benefactors of that power. They are supplicants.
I bow down.
Yes,
I bow down.
So all these. So when the balance is drawn between these, of course, the balance has to be drawn by the legislature and by the executive, not by us. We are quite conscious of that. But it's not therefore that you have an either or. Either you have this or you go back to an entire cash system. You can design another system which does not have the flaws of this system, which really they put a premium on put a premium on opacity. You can still devise a system which balances out in a proportional way. That's the point.
I'll just
how it is to be done is for you to decide.
I'll just
we will not step into that arena. That's no part of our function.
I'll just respond to Malod after showing the scheme. But let me respond the last point first, which is bothering your lordships. That this might be used as legitimized kickback. Well, first of all, whenever your lordships are considering a piece of subordinate legislature like a scheme.
Because, now these 5 considerations which I have listed out, you must now read in the perspective of how it has been implemented. First, there was a cap that your donation must be related to a percentage of net profits. A percentage of net profits meant that the company must be in a position to have net profits. And that you would donate 5% initially, then it became 7.5% under the 2013 Act. Now what have we done? Now we say that, well, it has nothing to do with whether you have net profits or not. In other words, the company may have zero profits, it may have zero turnover, but it gets a donation only for it gets a certain income or revenue only for the purpose of the donation. That meets
I'll
with
immediately say
that passes muster.
I'll immediately say, and your lordships may clarify that if that is the any concern, it's the right concern that so far as the condition with regard to the profit making company, that percentage of a net profit, a not profit making company cannot do it. But I understand, because then it would be used as a shell company. That is one of the objectives. We have removed 2,30,000 shell companies from the system.
So what will you do then? You will bring about an amendment to the Companies Act, government.
Let me take your lordships through this.
So you will move an amendment to amend the Companies Act to the effect that
amending, is a legislative function. I cannot make that.
But you have to move the amendment. If you
yes, or your lordships may read it accordingly.
No, is the government making a statement that we will amend the Companies Act to bring back the position what it was, namely that this will be only a percentage of the net profit?
No. I'm not saying percentage. I'm saying profit-making company can only donate.
But tell us something. Assuming that it's a profit making, it may have a 1 rupee profit, it may have a 100 rupee profit.
Yes.
Why would a company, if you don't have a percentage,
yes,
why would a company, for what conceivable reason would a company donate 100% of its profits? Because you have to take the extreme case.
Yes.
That's why I give you a 1 rupee company, passes the threshold that I'm a profit making company.
I have two answers.
I have a 1 rupee profit, but I will donate 100 crores. Why would a company do that?
I'll not.
Therefore, when, it can't be that, the government says that, well, it can't be that we lay down under 142 the principle that so long as you're a profit-making company, you can donate as much as you want. The reason why these caps were introduced and that they stood the test of time were for a very legitimate reason. Namely, that you're a company. Your purpose is to carry on business. Your purpose is not to donate to political parties. And if your purpose is not to donate to political parties, you must donate only a small portion of your, assuming that that's an altruistic motive, which is, of course, not so, but we will not go into it because nobody is challenging the 1956 Act provisions, the 2013 Act provisions. We are now looking at today's challenge.
May I respond to your lordship's concern? And it's a very valid concern, my lord. We share that concern.
Milords, I stand corrected. We have the data of the political parties. Yes. We have the data. I stand corrected.
Yes, Mr. Bhushan, what do you have to say?
So the first argument of the solicitor was that because of these amendments, the volume of cash which is coming to political parties, which he says are maybe black money or is likely to be black money, that has gone down.
No, that's not his argument. He doesn't make a quantitative statement. His contention is that this was an effort which was made to bring into the accountable channels what was otherwise completely beyond the fold of accountability because the earlier schemes had not worked.
So let me just deal with that. Firstly, my lord, it did not close the cash channel. The amendment has left open the cash channels. The only change that has been made is that for getting income tax exemption, that 20,000 has been brought down to 2,000. That's all. Otherwise, cash donations up to 20,000 can be given to political parties and they are not required to be reported. Quite apart from the fact that actually 20,000 or 2,000 does not make any practical difference because all that the political party declares is, I have received X crores as cash donations, which are below 20,000. They used to say below 20,000 earlier. Now, if they want to avail of income tax exemption, they say it's below 2,000. So they say that we have received whatever, 100 crores, 500 crores by way of petty cash donation. Earlier, petty meant below 20,000. Now, petty means below 2,000 if you want to avail income tax exemption. Practically, it makes no difference in my respectful submission to the availability of cash to political parties or the ability of individuals to give cash to political parties. Practically, that 2,000, 20,000 makes no difference. Now,
that will not impinge upon the validity of the scheme.
Yes, I know. Lord, they are saying that this whole exercise was to bring down the element of cash in the economy. They say cash is equivalent to black money. The object of the exercise was to make political funding of parties to come more through banking channels rather than cash. This, they say, was the stated purpose of this whole bringing in electoral bonds, one of the stated purposes.
Mr. Bhushan, there will be slight difficulty. Even if it has not happened, probably the data may support you, the cash channel may not have come down.
No, cash did come down. I'm not saying cash didn't come down, but the reason why, it's important to understand why cash
Mr.
came
Bhushan,
down.
There are four arguments on which we want direct answers.
Yeah.
One is that the intention was to ensure that the money comes through regular banking channel.
Yes.
There is a KYC required,
Yes, yes.
which is not there as far as payment cash is concerned. And also, even if it is coming through the bank accounts,
Yes.
the KYC by the second KYC at the time when the bond is purchased is a second added advantage.
All right. Let's assume that that's there.
Number three, their contention is that as far as payment is concerned, the person who's made the payment is concerned, the need to know the name of the donor has been protected. The confidentiality of the donor has been protected.
Yes.
For 1, 2, 3, 4 reasons.
Yes.
And therefore, when you are examining the reasons, you will have to take into account what was the intent behind the enactment, and not by a counter argument, which may be. And there has always been a conflict between confidentiality and declaration.
So, some Lord, in
Both of them have their pluses and minuses.
to answer our argument that these changes defeat the citizens' right to know about who's funding the political parties because they introduce another anonymous source of funding. Now, the answer given by the solicitor to that is that, well, it had an objective. Now, these are two conflicting things. They say the objective was to limit black money or cash money coming to political parties or to reduce that. And therefore, we introduced these electoral bonds because many individuals or companies do not want to be known that they are the donors to these political parties because they fear victimization. So that was what the finance minister then stated. That's the argument also of the solicitor.